This is for my administrative law class. I'm Dru Stevenson, and here I'm going to be talking about one of the big carve-outs from the Freedom of Information Act, Exemption 5, that says that agencies don't have to disclose certain information that's interagency or intra-agency memoranda. So let's dive in and see what this is about. So FOIA Exemption 5 exempts from disclosure under the Freedom of Information Act certain types of information, specifically interagency and intra-agency memorandums or letters that would not be available by law to a party other than an agency in litigation with the agency, provided that the deliberative process privilege should not apply to records created 25 years or more before the date on which the records were requested. In other words, this only applies to information from the last 25 years from the date that you're requesting it. If you're asking for memorandum that are older than 25 years old, from more than 25 years ago, the Exemption 5 won't apply. I'm going to give you one quick example of FOIA Exemption 5 in the courts. This is a case from 1975, the National Labor Relations Board versus Sears Roebuck. Sears wanted two sets of memoranda it hoped would reveal some useful intel about the NLRB's internal litigation policies for bringing enforcement actions. Sears in the 70s was this big nationwide chain of huge department stores, sort of like Walmart or Target today. And they actually were frequently in trouble or litigation with the National Labor Relations Board over treatment of their workers and employees, and specifically union activities. And so they wanted to kind of get inside the minds of the regulators here at the NLRB. And so they wanted memoranda that would reveal how they decided whether to bring an enforcement action once they had done an initial investigation. And so these were internal memoranda or memos between regional directors and the appeals council within the NLRB or the NLRB general counsel about whether to move forward with an enforcement action or drop the case or dismiss it. And the court here sort of split the difference. It's distinguished between pre-decisional documents and documents that embody the agency's final decision or position. And in this case, decisions to dismiss or not to file a charge were final. It was the end of the road for that investigation. If one of the memos said, we aren't going to pursue this any further, we don't have enough evidence of wrongdoing by the company or something like that, that's a final decision. And so those have to be turned over. They are subject to disclosure. Those would be binding on regional directors. In other words, once one of these memos said we should drop or dismiss this case, the case was over and the file should be closed. But there were other documents that were appeals and advice memoranda that actually approved enforcement actions and weren't the final step. In other words, they allowed the investigation to go forward. Now, they might change their mind sometime later and decide to drop the case or not bring the case. But at that point, the file remained open, the case remained open, and they were going to continue their investigation at the NLRB. And so these files could have still led to litigation or settlement offers during which the agency's position might continue to evolve. And so the court said that these are pre-decisional, even though they're made by the same people in response to the same interagency submissions, and therefore they are exempt from disclosure. I think that gives you an idea, that case NLRB versus Sears Roebuck, about what this exemption is covering when it discusses interagency memos. So having wrapped up our discussion of FOIA Exemption 5, I'm going to wrap up this video. Thanks for watching.